Thank you. So we give you at least talk about the webinar, and I proceed.
Yeah, basically to introduce you and yeah.
Okay, thank you.
All right. Well, a very good afternoon, East Africa, ladies and gentlemen, wherever you are joining us from. We hope you're having yourselves a very lovely Thursday afternoon. And this afternoon, while you settle in, please feel right at home. Share that link and tell a friend to tell a friend that our session has commenced, and our panelists are all in the house, very excited to share with you the wealth of knowledge. And this afternoon, we discuss a very interesting subject, one that is very passionate to those of us who love litigation, but to those of us who are enthusiastic about family law. And that subject is a discussion on customary law, customary justice versus formal courts. And we'll be discussing how alternative justice systems are shaping family law in Eastern Africa. Now, as you know, friends, in many African homes, justice does not begin in the courtroom. That we all know, that we all agree. It begins under the trees, the family tables, before our elders, or within community spaces where culture, identity, relationships carry as much weight as written law. That is an agreement. We don't need to even debate about it. But as our societies are evolving constantly, one important question will always confront us. And that question, ladies and gentlemen, is when tradition and constitutionalism meet, what does justice truly look like? And that is what today's discussion invites us to examine, not only on who resolves our family disputes, but who shapes values and outcomes and whose voices are protected, and whether or not our justice systems are evolving with the realities of the people. And that is us, friends. So today, to guide us through this very important and timely conversation, we are privileged to have with us, and please, Jemima, allow me to say this, to have with us Dr. Jemima Collins Aluda, a PhD
Thank you.
candidate with the University of Nairobi, a legal scholar and head of the Secretariat of Alternative Justice Systems. Now, with Jemima's deep expertise at the intersection of formal law and community-based justice, she's positioned to lead this dialogue with insight, balance, and regional perspective. Now, Dr. Jemima, I have my pen and paper ready, and the floor is all yours. I'm taking notes.
Thank you. Thank you so much, Gabriel. Thank you, our participants. And thank you so much, our panelists, this particular afternoon. Indeed, we're excited to have this discourse about how alternative justice systems is reshaping family law, not only in East African community region, not only in Africa, but also globally. Why is this discussion very important? It's very important because, ladies and gentlemen, the family is a very important unit in the society. It's actually, we all come from a family. And when we have disputes in the family, it affects not only the family level, not only affect the nuclear level or a extended family level, but generally in the community and the society at large. Why is this discussion very important? Ladies and gentlemen, we are looking at the plural legal systems that we have that can be able to enhance access to justice and promote cohesion at the family level. As we talk about family matters, we are looking at a whole array of family issues. It's from the family that we have domestic relations issues, we have family relation issues, and also we have community relations issues. At family level, it gives back to land disputes, succession and inheritance matters, child custody matters, maintenance issues. Of course, as we all know, also adoption and guardianship emanates from family related disputes, marriage issues, divorce matters, and also boundary disputes, especially when talking about extended families or brothers and living together and having these boundary disputes. This discussion is very important because we are looking at not only the interface between formal court systems and the application of alternative justice systems in the community, but what benefits do we have? What are some of the jurisprudence that you have that actually shows this interface working very well to enhance access to justice to the vulnerable groups? When we look at family matters, it brings a whole array of, in terms of the formal justice systems, it brings a whole array of different statutes that deals with family matters. For instance, Marriage Act, and this not only applies to East Africa, but as I've said, it's not only in Africa, but globally. Matters related to Matrimonial Property Act, matters related to Children Acts, matters related to land law, and also it brings on board other areas of the law, such as criminal law. Did you know that when you have disputes at the family level, then it gives rise to criminal law? And so there's also a connection between family disputes to other laws such as criminal law, to other laws such as civil laws, to other laws such as commercial law. So there's that whole connection. And so if we do not have proper mechanisms or effective way of dealing with family law matters, remember, it gives rise to criminal law, commercial disputes that we have in our courts, and also civil law. This particular afternoon, I'm joined with a very interesting panel, a very rich panel. To start us off will be Honorable Justice Professor Joel Ngugi. And Professor Joel Ngugi is a judge of the Court of Appeal of Kenya and the chair of the National Steering Committee on Implementation of Alternative Justice Systems in Kenya. He has earned both national and international recognitions, including the Jurist of the Year Award 2022, National Integrity Award from Transparency International 2023, and 2 Legal Tech Judge of the Year Awards, that is 2021 and 2022. Professor Justice Joel Ngugi has immense scholarly work on alternative justice mechanisms, but also on transformative constitutional application. And so, even as you look at some of his jurisprudence in courts related to family matters, they are transformative in nature and brings the intersect between the formal court systems and the alternative mechanisms. And what, which other way can we be able to have when you have that link that promotes people-centered justice? I'm also joined from Rwanda by Andrews Kananga, who is the Executive Director of the Legal Aid Forum, and he's been the Executive Director at this particular forum since 2008. And under his leadership, we've really had the voice of promoting access to justice for the vulnerable groups. And these vulnerable groups is what we are looking at today: the children, the women, the widows in succession matters, the women under marriage in Marriage Act, even the siblings themselves. When you're talking about the firstborns and the lastborns, when you have land disputes and family disputes. So these are the vulnerable groups that he has been looking at in promoting their voices. We're also joined by Ms. Barbara Kelly, who is a legal and governance expert and ADR specialist, and currently serving as the country director for international development law and organization in Uganda. He's an accomplished advocate with over 15 years experience in financial matters, regulatory reform, and alternative dispute resolution mechanisms. As I've mentioned earlier, under family disputes give rise to commercial disputes, gives rise to criminal disputes, gives rise to civil dispute. And you can see the reach that we have in terms of her expertise in other areas of the law. And she's been pivotal in promoting commercial justice reforms, not only in Kenya, but also in Uganda, and currently is working towards to ensure that Uganda promotes, fully implements alternative justice mechanisms. We're also excited this particular afternoon to be joined by Ms. Zenobia Ditua, who is a senior family law attorney and a director at Miller Ditua Cloit in Cape Town, South Africa. She's a specialist in not only national, but also international family law, which includes family law, constitutional law, and comparative law. So we'll be able to have these comparative studies in what she's doing in South Africa, but also global studies. Did you know that Zenobia has hosted 28 annual international forums on family law in University of West Cape? So who else can be able to give us global expertise other than Zenobia Ditua? To start us off, I want to introduce, to bring to you, ladies and gentlemen, Justice Professor Joel Ngugi. He'll be able to share with us some of the jurisprudence that we have in under his work as under his watch as a judge in court. What has he seen as areas of interest in family law? Well, disputants come to law. The court wants to resolve give a determination of disputes, but do we really get determination, or do we resolve the disputes that we have? And what are the underlying issues at the family level? What are some of the cases that we have in our courts that really calls for us to have this interlinked between between the formal court justice systems and also alternative justice mechanisms? Welcome, Justice Professor Joel Ngugi. Thank you.
Thank you. Thank you very much, Jemima. And thank you to my fellow panelists. I am very, very excited to be in this panel this afternoon, and I welcome our audience from wherever they are logging on from, but mainly I know most are from East Africa. This is a very exciting topic, and of course, those of you who know me know that this is an area of intellectual interest for me in the last 10 years. So first of all, let me just say, Gabriel, thank you for welcoming us. I do think if this thing with the EALS doesn't work, you have a future as a news anchor. So consider it. You did very well, and maybe you can start a TV show with Jemima. You seem to have real chemistry. So thank you, Jemima, also for the wonderful introduction. I want to lead off. I think my work here today is really just to frame the debate and then hear from the fellow panelists, and then probably respond to questions that may come. First of all, I want to lead off, and allow me, Jemima, to do so, to lead off by just making it clear that in AJS, we have tried to avoid what we consider a false binary between formal courts and what is called informal AJS. We do think that that binary is false. We think it's descriptively inaccurate, and we think it is normatively problematic. In fact, a lot of AJS mechanisms are highly formal in the normative sense. So to call AJS informal is, we think, many times a colonial framing. Instead, we distinguish between sort of rule-structured or technical based systems, which is what we do in court. We have highly structured rules, and decisions tend to be based on those rules, and relationship-based rules, or technical justice as opposed to relational justice. That is how I would view it. So I would like us to be careful in terms of using the binary between formal and informal. If we are talking about created by statute as opposed to not created by statute, that's a different conception, or created by the state as opposed to not created by the state. So having said that, let me begin by saying why today is very important for me. As someone who's been advocating for alternative justice systems in the region and in Africa generally for the longest period of time. And by the way, I should say that my ultimate ambition, I don't think it will be achieved in my lifetime, is that AJS will eventually lead to the indigenization of law, all law, or Africanization of all law in Africa, both formal, both procedural and substantive law. But that's for another day. For today, let me say this about family law. I do think family law is the one area of law where the purely adversarial justice, the limits is most seen, is most visible. And that is why it is the area of law where AJS becomes most indispensable. That is because in most family disputes, unlike in commercial disputes, when the dispute ends, parties walk away. They can easily walk away. In family disputes, when the dispute ends, the families still have to live together. If they are co-parents, they still have to co-parent. If they are siblings, they still remain siblings. The fact that the court says one person wins, the other one loses, does not stop their relationship. If it's an ex and a partner, you are still likely to meet that ex at a relative's burial. And by the fate of, the stroke of fate, the community might decide as a form of humor to sit you next to your ex. So you might still need to have that conversation. If it's children, they still carry that emotional burden. If it is communities, they still have to continue living together. So these are all the stuff of family law, which is why if you look at the literature and the cases, family law has always very quietly resisted the logic of adversarial adjudication. And that is why it is a good place to begin studying the promises of AJS. So, in my view, the question in family law is not merely who is legally right. The question is often, what is the resolution that will preserve the dignity of this family? What will preserve these relationships? And what will preserve the future of this community? Often, the adversarial legal system does not give those options. So just briefly before I delve into example, I wanted to give you reasons why I think family law pulls naturally towards AJS. And I just want to give you 5 very quick ones. First of all, as I have just said, family disputes tend to be relational in nature. I think we can all agree on that. And often, parties want to retain their relationship, or at least they had a relationship before, and often that relationship needs to continue existing. The adversarial legal system, without hybridization, leaves very little room for that. Secondly, family disputes tend to be emotionally textured. They're emotionally textured in the sense that a lot of the adversarial litigation, when it unleashed on family disputes, they tend to escalate stigma, they tend to escalate humiliation, a sense of shame, and so forth, which many people naturally tend to avoid. AJS provides a natural place where that can happen. Thirdly, and for me, most importantly, at least from my judicial work, we see, at least in a lot of in African countries, what I call disguised dispute problems. By disguised dispute problems, I mean problems which are presented as legal disputes, but in fact, what is at stake is a relational injury. What that is to say that often family disputes have their own grammar. That grammar is not necessarily comprehensible in law. So when parties have nowhere else to go but to come to court, they are forced to comprehend and speak about that dispute in a way that is pigeonholed in the law. Okay, so what comes as dressed as a legal dispute might actually not be a legal dispute at all. It is often a very deep, unnamed, relational grievance, which, if you go to a lawyer, because they do not have a name for it, they will have to find a pigeonhole in law. So they will have to call it succession, they'll have to call it custody, they'll have to call it maintenance, they'll have to give it a name. But often, that is not what is really at issue. I'll give you an example, just two very quick examples from my own experience as a judge. One is a prominent case I dealt with in when I was at the High Court in Nakuru, a succession matter which had remained in the courts practically for 9 years. Parties had disputed with each other 9 years. The matriarch had died. Basically, it involved the estate of the matriarch. There was really no dispute about the beneficiaries. There was really no dispute about the extent of the estate and what the estate assets were. And it was just curious to me. I arrived at the tail end of that case, and it was very curious to me what the real issue is. When I eventually asked the parties, I called the parties, there were 13 children in the family, 12 were still alive, and I called them to the courtroom. And I said, what seems to be the real issue here? After about an hour and a half to 2 hours of discussions, it emerged to me. And this is what the firstborn said to me directly. The real problem in this case is that my siblings over here do not recognize me as the firstborn son. That was a real dispute. They don't recognize me culturally as the firstborn son and give me the respect I deserve as such. That dispute had been framed by the lawyers as a dispute where the firstborn son was claiming a bigger size of the estate by virtue of both inter vivos transfer and the fact that he had contributed to the family estate. It turned out that that was not the issue at all. The issue was just he just wanted to be recognized. Now, if that case had gone to trial and, a 26 witnesses later would still have come to the same conclusion. Maybe it would have taken 5 more years. I don't know. But we would never have addressed the real issue because I would never have written a judgment where I tell the other 11 siblings, now you need to recognize your firstborn culturally as a son, as a firstborn son. That cannot be comprehended in our legal system. That can only be in a relationship dispute resolution setup. Now, a second example I want to give, it's not really an example, but it's really an anecdotal research I did also in Nakuru, where there are a lot of high-end succession dispute, and I looked at 20 of them. The average time it took for a succession matter in Nakuru was 9 years. I looked at the 9 most prominent ones, and this is what happened. This is what I found. In all the 9 of them, the dispute took up an average of 9 years. In all 9 of them, the outcome was the same. The courts just ended up saying the law is clear that each of the siblings get an equal share, whether male or female. So there's no question what the law is. Yet parties insist on litigating these issues for many, many years. What does that tell us? What that tells us is that the problem is elsewhere. The problem is not really in the letter of the law. The problem is not really in trying to establish you're a sibling and so forth. It is that people are dressing up their claims in legal ways that are really not the issue. What they are really litigating are relational claims which our courts cannot give. For me, that is the biggest reason why family law is the best place for trying alternative justice in our current setup. As I end up, let me just say this. The practice of alternative justice system does not mean 2 things, which people often confuse. Number 1, it does not mean that we are now legalizing private injustices or constitutionalizing private injustices. It does not. In fact, in all the East African countries, what our constitutions now provide is that alternative justice systems must be practiced in the mold and substance of minimum constitutional guarantees. Then what that means is that the Constitution does not constitutionalize traditions and customs. The Constitution constitutionalizes AJS, which has been created in the image of the Constitution. So the risk of human rights violations then are mitigated. And we start talking about operationally, what are the things then we must do to ensure that if matters are being resolved in alternative justice systems, those minimum constitutional standards are being adhered to in all instances. Number 2, at least in the case of Kenya, and I'm aware that is the case in the other East African countries as well, the alternative justice systems as it has been conceived does not displace the role of lawyers. In fact, it emphasizes the role of lawyers as advisors in the process, especially when it comes to the human rights minimums. But secondly, as it has been conceived, the alternative justice systems now in our region, and I believe that is true for the rest of Africa, follows at a minimum what I call the agency principles. In Kenya, we call it explicitly the agency a theory of jurisdiction. What the agency theory of jurisdiction basically provides for is that at a minimum, first prong, for a matter to be sent to AJS, is there must be knowing voluntariness. Knowing voluntariness meaning that a party has decided of their own volition in excess of their civic autonomy to go to an AJS mechanism as a mechanism that optimizes their purposes for that litigation. So they are making a knowing choice to enter into the AJS mechanism. Secondly, the agency theory of jurisdiction also tests to make sure that the particular dispute is not one that the Constitution has said cannot be subjected to AJS. Also, it is one that cannot be subjected to statutory, that statute has not said cannot be subjected to AJS. And thirdly, it's not one where compelling public interest says cannot be subjected to AJS. If that is adhered for, then it becomes an extra layer of a protection for purposes of constitutionalizing AJS. Let me end there, Jemima. I am sure my colleagues are going to say a little bit more, and then at the end, we can answer any questions that our esteemed participants may have. Thank you very much.
Thank you so much, Judge. Thank you so much for even just giving us the icebreaker and the teaser and bringing the new vocabulary that we have. The grammar of family matters, the grammar that lawyers comprehend when they come to court, looking at matters as either succession or child custody, yet just an issue that needs to be resolved by parties and not necessarily a dispute. Judge, you've really contextualized why we are here today to discuss about family matters and its importance. One of it being the emotional texture that family matters bring. The issue that you are parties forever, whether you are divorced, whether you are separated, whether you are connected in one way or the other, you remain parties forever, even in death. And the problems that we have in the society that need to be resolved outside. But more importantly is the fact that alternative justice system is not about informal mechanisms, but there's a link between court systems and the other systems, and we need to work together. For instance, if you want a succession matter to be resolved effectively, when you file the matter in court and the court can allow you to have this discussion outside and then come and file consent. Once you file consent, it's only the court that will be able to give you the grants. And so there's that interface between court systems and alternative systems, and we need to be able to embrace. Our second panelist from Rwanda is coming to give us now the real practical examples on how they've contextualized the plural legal systems in Rwanda, how they've been able to deal with the rights of the vulnerable groups in Rwanda in family matters, and generally, how is the alternative justice system reshaping family law in Rwanda? Welcome, Andrews from Rwanda, the Executive Director of Rwanda Legal Aid.
Thank you very much, Jemima, and thank you very much, Honorable Justice Professor Ngugi, and other panelists and the organizers of this. I think Prof has made justice to this session, and I just want to come in with the perspective from Rwanda. So just to start off, I would like to maybe to remind you something that is by now obvious to all of us. Rwanda, I guess everyone on the platform will understand, especially if you're from East Africa or even those beyond East Africa will understand that Rwanda went through a genocide, and that meant that after the genocide, we had to look at alternative justice systems as opposed to, and I like the way how Justice George Ngugi put it. I think when it comes to formal versus informal, you will find out that Rwanda actually we have dealt with that problem. We do not have informal versus formal, and I'll come back to that. So one of the things that we did as a country by trials of the people who were suspected of the genocide, we relied on our traditional way of resolving conflicts, where everyone was involved. The justice was very quick, and the communities were looking at serious crimes. Probably this is one of the things now people who have not understood this would say, oh, how do you get communities involved in trying serious crimes, in like genocide, but also cases like cases of rape. I want to remind the audience that during the Gacaca trials, we had about over 8,000 rape cases that were being handled by non-jurists, the community themselves through the Gacaca system. And from that time, I think we learned a lot as a country. After we were done, Gacaca started around we started the pilot in 2019, 2000, and then we rolled out the process in 2004. And by 2010, 11, we were closing all the trials. But a lot of the legacy that the process left behind was also for us as a country to go back and look at how do we then institutionalize some of these practices to deal with some other legal issues like family law issues. Now, family disputes in Rwanda continue to be resolved since the Gacaca continue to be resolved through formal court systems and community justice systems. And Rwanda has broadly integrated ADR into our own system. So Gacaca set the bar very high for us. After the Gacaca, we also have now another system. It's not Gacaca, but the biggest system we have that look at community justice is called Abunzi. That one came in sort of after, they started at the same time with Gacaca, but I think we've been able to, maintain that one as our way of dealing with community justice. And most of what they're dealing with is family. So we have in Rwanda a lot of structures that look at family issues. Our family law has introduced, we had, that one was reformed about 2 years ago, has introduced other layers of structures within the community where justice-related issues can be resolved by community members. Now, we have what we call family councils, local administration authorities, Abunzi committees, and then currently we have added professional mediators, of course, formal court systems coming. Now, some of the issues we have, like we're handling at our legal aid clinics, I would say 70% of those relate to family matters. And this is succession, it is inheritance, it is custody, it is where divorce is handled at a different level, but all the issues, as we said, someone, I think when he was introducing justice issues they don't start in courtroom. But also our structures are allowed to, not very much to enter into divorce, but when it comes to divorce and child custody, our families, our community structures are very much involved. So the typical examples where I can give of cases we have, I think, and we've been involved in is more to do with succession and inheritance. And these are handled by our clinics. Because some of these cases have to go through what you call informal or community justice structures before they can go to our court. The Abunzi are allowed to handle anything that is not beyond $3 million in francs. That dispute has to, go through our community justice systems, commonly known as Abunzi. Now, in terms of the other thing that family law is looking at, it's also looking at guardianship. To some extent, we're also involved in adoption, especially when it's not inter-country. We look at settlement of succession-related disputes, and different structures are involved before these matters can go before our courts. We also have other structures that the government has mandated to look at family issues. We have what we call community assemblies that happen every week. And these community assemblies are allowed to look at minor issues, minor disputes arising from the community. They try to settle that at their own level before they can be forwarded to court. But majority of these get resolved through the community. We also have what we call friends of families. Within our family settings, we have what we call family friends, in our language. They were established by law in 2016. And they are also allowed to look at family issues, try to do some mediations before matters can go to court. Now, We also have paralegal systems. They're also contributing to resolving family issues. Paralegal, I know you also have them in Kenya or across East Africa. They deal with a lot of family issues before they can go to court. So what I can say is that Rwanda, as a country, I think we are now at a phase where we think majority of family disputes can be resolved within these local structures. So we do not have customary courts as we have in Kenya. So everything in Rwanda has been formalized. Every structure that is dealing with the dispute, there is a policy, there is a law to that. So we do not, I think one of the things the Belgians did, I think that was really is to make sure that Rwanda does not have chiefdoms. So everything was codified from a long time ago when the Belgians came here. And that's why when the genocide happened, we are trying to go back and see what can we do? Can we bring back our informal justice system? But everything in Rwanda is codified. There's a policy, there is a law. Every conflict in the family that is that arises in the family, there is a way of handling that. And as a result, I think one of the questions you asked in the concept note was to see the legitimacy of the decisions that are being taken on these matters. So we've made sure that courts supervise everything that is being done, these mediations that are being done. And as a result, for decision taken by Abuzi, for instance, they will be looked at by a judge to make sure that constitutional guarantees are adhered to, and there is no violation of the constitution. Even our constitution itself talks about how these family disputes can be resolved through these informal structures, if you like. So I will end here. If you want, I will come back. But I think Rwanda offers a very good example of how, when Professor Ngugi said, I think we should stop calling our institutions informal. Rwanda, the way we resolve conflicts is not informal anymore. So there is policy, there is law, there are guidelines on how you want to deal with every conflict, and the courts, the judiciary is involved, especially when it is believed that the constitutional principles have been violated. Thank you very much. I will stop here, but maybe I will come back later after others have spoken. Thank you.
Wow, thank you so much, Andrews Kananga. Thank you, because you've really demystified a lot of issues here in terms of even the language. Is it informal? Is it formal? Just emphasizing on our initial presenters' perspective that we should not call this informal or customary or local. We have languages that we use that can be able to give these justice mechanisms just the same dignity that we give in court. And so that's why we go by the approach of alternative justice mechanisms. Indeed, you say that in Rwanda you have guidelines and policies and acts. Same applies to Kenya, Uganda, and across the country, South Africa, and even in Ghana, where even though they use the chiefdom, but they still have an act that deals with this mechanism. So that language is very, very important. Secondly, you've highlighted a very important people or how these alternative mechanisms fashion themselves in the community or in the society through the family council. But what I like is the community assembly. That's language, community assembly, family, friends of family or family friends, using these as people can be able to resolve the disputes. You've also emphasized the role of paralegal. So you have a paralegal system, community systems. And yes, we are a testament through the Gacaca courts on how these justice mechanisms working hand in hand with the formal court systems can be able to enhance cohesion in the community. Ladies and gentlemen, our topic for today is how alternative justice systems are reshaping family law in Africa, even though being hosted by East African Law Society. We've expanded this particular topic to look at African perspective. And who else other than Barbara Kelly bringing the perspective from Uganda, but also how IDLO has worked in different countries in Africa and also beyond Africa in terms of promoting the diverse pathways to justice through alternative justice systems. Barbara Kelly, the stage is all yours. Thank you.
Thank you, Jemima, and to the team that has worked to organize this particular conference. We are truly honored, and it's a pleasure to join this panel to see how best we can advance diverse justice pathways in plural systems. So I think I would first want to begin with one central point, that if we are serious about access to justice, then we must start from how people actually seek justice, not only from how as Justice Ngugi said, how our formal institutions are designed, where we normally think about high courts. This is because across the world, people resolve disputes through a combination of pathways. There are different courts, administrative bodies, community mechanisms, religious leaders, customary institutions, legal aid providers, and so on and so forth. So in plural systems, the task has not been, and I think this is why Judge Ngugi says it's a false binary. It's not about one pathway or another. I think the most important thing that we can do is to improve on the integration of the justice ecosystem, which ensures that justice systems or justice services are accessible, trusted, rights respecting, and responsive to people's everyday needs. And this requires actually a global shift from the institution-centered reform that we have always been seeing to more of people-centered justice reform that is grounded in evidence, inclusion, and practical coordination across all the different pathways and actors. So we can already start to see, especially from an IDLO perspective, that global thinking on people-centered justice is increasingly moving towards that direction. The emerging consensus that we can see, especially as reflected in the OECD framework and the recommendation on access to justice, is that justice systems should be understood as ecosystems with stronger interagency cooperation and accountability, and a focus on the justice needs that people experience in everyday life. Now, IDLO, the International Development Law Organization, we are an organization that's exclusively devoted to promoting the rule of law. We have taken leadership in the Global Working Group on Customary and Informal Justice Systems and Sustainable Development Goal 16, which is on promoting rule of law. So this is a unique coalition that actually includes a broad array of actors from the UN and other international intergovernmental agencies to grassroots justice defenders and community groups and the advocates for the centrality of diverse pathways to justice in achieving SDG 16. Now, in 2023, the working group published a Diverse Pathway to People-Centered Justice. This is a landmark report that articulates a new consensus on the need to engage all actors, including CIJ practitioners, in an effort to enhance access to justice. So, demystifying the fact that justice is a reserve of a few and a reserve of a few institutions. So the efforts there are to enhance access to justice and strengthen the rule of law. And we believe it serves as a basis for multi-stakeholder collaboration on customary and informal justice policy and programming at the global level in years ahead. Now, this particular justice group will actually launch a global campaign which is called Justice Within Reach. This is a 3-year effort that hopes to put diverse justice pathways at the center of the global justice agenda through actions at both global and national level. And the launch will be on Thursday next week, which will feature the Chief Justice of Mexico, the Director of Access to Justice at Ministry of Justice, Burkina Faso, and many others. So if you're interested in that, you can actually check it on LinkedIn and find the information, which is the hashtag is Justice Within Reach. So this actually shows why IDLO is keen on working with the different states, civil society, and informal justice actors to strengthen diverse pathways to justice anywhere. You may wonder why so. So I'll give you a couple of stories from Uganda, and please allow me to do so, given the limitations in time, which show why diverse justice pathways make administration of justice possible. I'll begin with Akiki. Akiki is a lady from Western Uganda, a region called Kabarole, who lost not just her marital home, but also the land that she was due to inherit from her parents. And this was by exploitation from her relatives. Now, she could not access the formal courts because of the costs that were involved in it, and she turned to community mediation processes and supported by legal aid actors, that is the Uganda Law Society Legal Aid Project, which is funded by IDLO. And through the mediation process, she was able to actually regain both properties. And in the process of regaining both properties, the community elders learned the value and the rules that are included in the Constitution and in the various Family Law Act, which is that when it comes to intestate succession, that there are certain parameters that are involved, including the right to property for the widow, that they are not excluded simply by virtue of the death, nor are they excluded from their inheritance by virtue of being women. So this story illustrates a core strength of diverse justice pathways that can restore rights while also building relationships and confidence in justice systems. Now, if we move closer to Kampala in Namutumba, where one of the religious leaders emerged as a trusted justice actor, mediating disputes that actually encouraged women's participation and linking the different community process with the justice systems that are there. So the local council courts that are actually established by an act of parliament, but have informal processes which allow for peer dispute resolution processes, if you may so call them. So this shows how plural systems can work best when trusted local actors serve as bridges rather than substitutes, so helping to shift the public attitude and expand confidence in justice services. Now, the last story I want to share is Rukia's experience. Because sometimes when you look at justice or informal justice processes, we limit them to civil and family matters. But sometimes we also have to consider how, after the commission of a criminal offense, there is importance of reintegrating or restoring relations that people or accused persons have with their families. So when you have someone who has already been convicted of an offense, there is always the fear that they have when their sentence is about to be over. How do I go back to the same community that I lived in and continue living my life and engaging in sustainable livelihood to either fend for my family or my children? And Rukia's experience is important because it showed us through legal counseling and support, not just for Rukia, but also for her family back at home, provided a scenario where she was welcomed, because we've seen, and globally reports are there to show it, that women are rarely welcomed after serving a sentence, that the society is more mean to women when they have committed offenses and do not welcome them back. So reintegration is important. So these stories tell us that it is important that the justice systems are visible in the lives of the people that they affect, that they are trusted, they are accessible, and they are connected with the different justice pathways that exist. And one case that I could talk about is the Annette Yosia case, which was against Ambassador Amoko and the Attorney General. This is a case that involved Supreme Court Judge Justice Stella Arach, a dispute over her burial, the burial grounds. And you can imagine a Supreme Court lady judge lying in the morgue and the family fighting over where she's to be buried. And simply because the children did not agree with the father on where the burial place would be. So the father insisted, or the spouse insisted, that the burial needed to be at the marital home, whereas the children believed that she needed to be buried where she had directed them, which is in her own ancestral home, because not just of her connection to her ancestral home, but also due to the fact that she was a princess of the Jonam. So at the end of the day, when the court made the decision of where she's to be buried, because the court makes a final determination, I think it is important that we reflect on how the dispute management process missed the earlier window of using the other justice systems that exist, which even included mediation or customary deliberations that would have facilitated a structured and a safeguarded resolution pathway away from the eyes of the public, preserving the dignity of the family and preserving the relations between the first applicants, who are the children, and the respondent, who was the father. Because we believe as IDLO that the future of justice lies in recognizing and strengthening these diverse pathways that people already use. And this experience has showed us that plural systems can advance access to justice when they are treated as connected ecosystems supported by evidence, anchored in rights, and designed around people's needs. So the different Ugandan experience clearly shows and underscores this lesson, and it factors in the fact that progress does not come not just by replacing one system or the other, because that is not what we are asking for. We believe that there must be practical linkages built across the different pathways that facilitate accessibility, trust, and improve on confidence in the terms of justice delivery, so that we can focus on restoration of relationships, promotion of dignity, improvement in terms of participation and social stability. In Somalia, where we have supported the different establishment of ADR centered, these are mechanisms that have been built to facilitate the resolution of disputes through mediation. And these centers allow for the application of either the formal laws that have been published by Parliament, or Sharia law, or customary norms of the people of Somalia. Now, the centers have a defined operational system. So each center would have a roster of adjudicators, a clerk, a community paralegal, and cases here, when they're registered, they're recorded and classified, and their processes are guided by standard operating procedures. What is important is that in these centers, the jurisdiction is clear. When it comes to family disputes, it is limited to consent for marriage issues, child care and maintenance, inheritance, and certain domestic disputes that can actually be addressed. Matters that are actually outside those three areas that I've mentioned would have to be referred to formal court or other avenues. So services that are also additionally provided in that center include health and psychosocial support. Now, the other service that is provided here, or rather the other advantage in this particular center, is with regard to the inclusivity that is deliberately built into the system.
Okay, Barbara, you can try to wind up. You can try to wind up. Thank you.
So the adjudication panels in the Somali ADR centers would include the elders and the sheikh, but you would also find the women leaders and IDP leaders and the youth representatives, which show that you can widen the participation without undermining legitimacy. So there are three priorities that I would like to mention, and I'll just mention them, is that when justice systems are connected through referral pathways, dialogue, shared understanding, and practical cooperation, justice systems becomes more responsive and more effective in the administration of justice. The second is that if we put the needs of the justice seekers, especially women and excluded groups, at the center of administration of justice, then these diverse pathways can widen access, and they can also ensure that there is equality when we monitor their application. And finally, is the importance of evidence. We need to invest more seriously in evidence, learning, and accountability, and accept that when people use diverse justice pathways, then we'll be able to understand what works for who, when, and under what conditions, so that we are able to also inform the OECD People-Centered Justice Framework and Toolkit and facilitate the use of data for the administration of justice. Thank you very much, and I hope to hear more from the other panelists.
Thank you so much, Barbara. If you are to, some of us have been called the news anchors of the day, but I can call you now the person who has been given the anointing to preach to people so that they can get converted and promote people-centered justice, the diverse pathways of justice. Indeed, you've really brought in a very interesting perspective on the need to bridge the gap. We look at these alternative justice systems as not as substitutes, but as a bridge, number one. And number two, we look at them as the experiences of people, the justice journeys of the people, so that by the time somebody is coming to court and staying in court for 9 years, for 7 years, what are these experiences that you have? The dignity and the good example that you've given about the Supreme Court judge. And you've really said that we need to strengthen the rule of law, and we can only strengthen the rule of law by promoting people-centered justice, inclusion, look at the justice ecosystem as a whole. Yes, that's the new grammar that Prof was talking about. So now Barbara has given us a new grammar. When you live here, we're talking about justice ecosystem, looking at it holistically and not just from a single lens or a single perspective, but conclusively, what are some of the justice pathways that we have in our communities that will be able to work together to enhance access to justice to people? But more importantly, we are all promoting people-centered justice. I have a couple of questions online, which I'd like my panelists to start thinking about, even as I present the next presenter. Justice Professor Joel Ngugi will be able to look at the constitutional bit, why if somebody is excluded constitutionally from the justice mechanisms, are we still talking about equality of the law, or are we discriminating? For instance, this system does not give you the right to be able to use alternative mechanisms, but maybe use the formal system. Are we looking at it in terms of discrimination or equality to the law? Barbara will be able to address the issue of the vulnerable groups. When we have challenges of the vulnerable groups, how do we ensure that the vulnerable groups are equally represented and can equally participate in these mechanisms? I'll be able to present the next questions. Ladies and gentlemen, we've moved from Kenya in terms of terminologies. We've gone to Rwanda in terms of now legal aid, the legal aid, and what are some of the mechanisms that we have that Rwanda legal aid utilizes or uses to be able to enhance access to justice to the people, and the policies and the laws that they have. We've gone to Uganda and looked at a few examples, and the interesting one was the one for reintegration. Did you know that recidivism is mainly caused by people not being accepted when they come back from prison after being in prison for quite some time? When they come back to the community, they're not accepted, and now they commit an offense and go back so that they can go back to prison. If you do not know, you can read a story called The Prison Monger, of why this person loved the prison. And one of the reasons for recidivism is actually this, why we cannot be able to embrace or promote restorative justice so that there's healing and reconciliation in the community. Our next presenter or discussant this particular afternoon is Zenobi. And interestingly, she has hosted 28 annual family law conferences or convenings at West Cape. So if you've not attended one, please look out for the poster for 2027 March, so that we all roads will lead to University of West Cape. So she'll be able to give us a global perspective from all these conferences and convenings in the discussions, and being a scholar in family law matters and mediation. How is alternative justice systems reshaping family law in Africa and globally? But even as she does that, I'll encourage us to continue posting our questions on the chat. And number two, I'll also be inviting you to our AJS Conference 2026 in Embu. I'll be able to share the details shortly. Welcome, Zenobi.
Thank you so much. And it's a real privilege to be part of this very informative and thought-provoking panel. Thank you all. In South Africa, we have an overarching constitution that entrenches rule of law and equality. Best interest of children are paramount, and families are very important and entrenched also in the family. There's recognition of traditional and customary law as well as freedom of religion. Professor Ngugi, I'm very excited. I'm going to borrow your relational justice term for South Africa. It's wonderful. And just to add into what other panelists have said, we had a pilot project in one of our magistrates' court on mediation, and one of the participants said, quote, "It's much better than being in a court system when you mediate. You sit at a table like a family, neighbors, whatever, and you're just getting out of frustrations and validating, and you might not know what the other person's journey is. So then you get to learn a bit more and understand and make a solution that's helpful to both parties. To negotiate is important." And that really entrenches why alternative dispute resolution has become so important. In our democratic state, there are various challenges: access to justice. To deliver fair and efficient settlement of disputes is problematic. There's a lack of resources, enormous costs of litigation, long delays, traumatic effect of these delays, particularly on the fabric of families. Mediation has had a very long history in South Africa. And it aligns with our African heritage as well as with our recent history. The South African Constitutional Court supports the distinction between compulsory mediation, the coercion to enter into mediation, and the participation in the process and having to reach a settlement. In other words, if you participate, you're not obliged to reach a settlement. Mandatory mediation was therefore regarded as an allowable limitation on the access to courts. Our Children's Act provides for alternative dispute resolutions, such as family group conferences, lay forums, which include traditional or religious authorities, although the court still has an overriding discretion. There's also the Lekgotla and Kundla traditional gatherings led by chiefs along with the Council of Elders. The primary goal there is restorative justice, Ubuntu, communal harmony, reconciliation rather than punitive action. Community mediation and facilitation takes place. They're faith-based and community leaders who participate in mediation processes. Community advice offices have been established in many townships and outlining marginalized communities, working as quasi-mediators. In mediation, people value being heard and the wisdom taken to the process, as well as the positive change that emerges. Lawyers can participate fully. They can either be mediators, there's caucus, which is lawyer-assisted mediation. They advise their clients through the mediation process, and it's actually an all-embracing culture that has been established in South Africa. It has a tremendous following. Our Law Commission has now published an ADR bill that seeks to regulate mediation in certain respects, although it is still very much a fluid process. Lawyers, psychologists, or suitable persons can be mediators. They will have to belong to a supervisory body. Certain standards will be set, procedures will be set, particularly in regard to children, ethical standards, and so on. The onus is on legal practitioners in terms of this bill to explain the advantages of mediation, the costs thereof, and the options in regard to clients. Litigation has become increasingly problematic. Judgments are delayed. There are not enough judges who are able to facilitate service delivery. For example, in 2021, we scored 50% for compliance with the rule of law and also 60% for adherence to civil justice. It's a battle that's ongoing. ADR mechanisms are required to move forward with the access to justice. There are various pro bono projects. The objects are to facilitate an expeditious, cost-effective resolution, to determine at an early stage whether to proceed or whether to attempt restorative justice to protect and respect the inherent dignity of families and the person. What is also set out in the ADR bill is arbitration, which has traditionally been excluded from family law matters. They are now seeking to include it in family law matters, particularly in regard to all aspects thereof, also children. This is to avoid delays, ensure due process, harmonize different approaches, and as one of the UK judges said, courts and arbitrators are in the same business, namely administration of justice. International best practices has developed. For example, early case management, video conferencing, detailed procedural rules, evidence, burden of proof identified, balance of probabilities as far as proof is concerned, evidence gathering, submissions, witness statements, and so on. Discrete issues may be arbitrated, which solves many problems. Arbitration process is transparent, confidential, with as mediation autonomy to the parties to find their own solutions. It's innovative, dynamic, adaptable, evolving, speedy resolutions and outcomes. The choice of arbitrator is streamlined, as is the choice of mediator. It's efficient, convenient, and it gives early determination of disputes. Guerrilla tactics to disrupt or delay processes are discouraged. Changes may be rejected if it's found a party is abusing its rights. Very importantly, diversity is a big focus in these ADR procedures. The international trends follow the entrenchment of alternative dispute resolution instead of litigation as such. Particularly with our rich culture across Africa, with African law, Islamic law, European law, multi-plural systems with different approaches, it makes sense to find alternative dispute mechanisms with a growing approach to standardization of laws and procedures, yet retaining each country's unique character. Language and semantics have become important. How various aspects of identity, such as nationality, culture, and background, can have an impact on the party's perception of the mediator or arbitrator, ultimately the outcome, and also hidden biases that may exist. There must be education regarding diversity, cultural and religious differences, different regimes that may apply. Constitutional issues, however, will remain paramount. What are concerns in these processes? There should be compulsory disclosure in some or other manner upfront, where, for example, property disputes are being mediated or arbitrated. Otherwise, parties cannot make informed decisions. It should not be used as a method of manipulation to postpone disclosure. How about children heard? This is most important. Mediators and arbitrators require to be trained in this regard. They may be heard through our family advocates, psychologists, a curator, a legal representative. But if mediators interact with children, this is a very important aspect. Their rights should be protected and their voices should be heard. They should be informed of processes and of the outcome thereof. Domestic violence, of course, is a big issue, and there should be assessments as to whether a process is suitable for mediation or arbitration. It's, however, found that very often mediation works quite well. Parties sit separately. A party may bring a therapist. Parties should be protected. There should be security systems in place, for example. But strangely enough, in one of the pilot projects in one of our domestic courts, they have found that many of the domestic violence cases have disputes which actually fall outside the domestic violence realm, and 70% of those cases have been mediated successfully. What will be privileged? The process is without prejudice, which assists parties who don't want publicity of their matters. Is it a piecemeal agreement, or is it only agreement in totality that needs to be ascertained? There should be quality of processes and resources and quality of training of mediators and arbitrators. As a final submission, if one looks at international cross-border processes, which are occurring more and more, there has to be specific training for arbitrators in this regard, and they must be more experienced. You are dealing with, firstly, a jurisdiction race across various jurisdictions. The forum of the mediation or arbitration must be agreed on the basis that that doesn't prejudice an acceptance of whether the one place is preferred above the other place jurisdiction-wise. Mediator must be aware of differing laws in the differing countries. Also, whether the outcome of the mediation can actually be registered and implemented in the other country. Otherwise, the whole process will be completely futile. There should be disclosure. The presence of domestic violence should be investigated. One must look at cybersecurity and AI, how matters are heard now online. Again, privilege and confidentiality must be identified early on. Communication and the archiving of documents must be protected safely. Are there to be written contracts, review of lawyers of the written contract? How are conflicting statutes reconciled? And there must be strict ethical rules. I may, in question time, if there's time, talk about our parent coordinators who glorified mediators in all our parental rights and responsibilities matters. They mediate post and pre-divorce. Thank you.
Thank you so much. And I can see that you have a whole paper, which I believe that you share with us so that you can read more. The emphasis on the imperatives of our alternative justice systems. You've also emphasized on the need for training, and not just training in terms of the areas of the law, but an interesting aspect on issues of how to deal with trauma, even in when you are handling this particular, when you're mediating matters related to children. And this connects to what our first panelists presented on, that family matters are have a lot of emotional texture. And if you want to also mediate globally, then you also need to understand the laws of other countries and other areas of the law. But what is interesting is the plural nature that you brought in, for instance, the example that you gave in South Africa, where we have the application of the European system, you have the application of the African system, you have the application of the Islamic system, you have the application of the Hindu system. So all these systems need to be applied, and the need for us to coordinate. That's what we're coming out of from this particular webinar. We have diverse pathways to justice. We call them the plural systems, but the whole essence, they must all work together and fit the justice needs of the justice seeker. Ladies and gentlemen, we've received quite a number of questions on the chat, and I want to bring our panelists now on board. But to start us off, and somebody that I believe should be able to give us her voice, because she's the chair of the East African Family Law Committee, and who we were working together in terms of setting up this important webinar. I think it's the webinar of the year from the East African Law Society perspective. There cannot be any other better than this, because family matters are very, very key. Is Patricia Mundia. Patricia Mundia, we want to hear your first question, and then I'll be able to bring on board other questions that have been raised, which I've allocated to our panelists in the chat. Thank you.
Thank you, Jemima. Quite wonderful moderation from you, Daktari. I've been guided by Gabriel today, and I'll be addressing you like that from now henceforth. I want to just take this opportunity to thank our panelists. I have been blown away by all your presentations. I've also seen my senior, Dr. Musau, saying that the papers need to be shared. So I don't know, we have to work on that through, of course, Jemima and ELS, and see how we can circulate, I think, because this ultimately benefits families in the region. Now, just to start us off, of course, as even we go through the questions, one of the objectives we had when we thought about having this webinar was to, of course, one, have a better understanding of AJS systems amongst advocates and lawyers in our region and Africa, and even beyond. But also, the question I would have to most of the panelists is, where do you see lawyers fitting in this system? I've seen one question that is concerned about the bread and butter issues we always talk about, that at the end of the day, lawyers are also looking for opportunities. We know we have more lawyers now in the region. We have many young lawyers as well who are looking also for work. Where can they find these opportunities? I hear there's, Andrews, you've talked, and Barbara, you've talked about, of course, the vulnerable groups and the need for legal aid. But how can these systems also just get that to that step further and give lawyers an opportunity to speak? So I would probably, Jemima, want to listen to Honorable Judge on what he thinks and has had as an experience in the AJS committee. Of course, Andrews and Barbara would really rely on the opportunities as well that you think are there. And Zenobia, I know you've touched a bit on how lawyers have been involved in mediation and arbitration, but I think maybe you can expound more on other opportunities that are available for lawyers. Thank you.
Okay, thank you so much. So as they answer that important question, so I'll be able to now bring my question so that the panelists will respond to that issue of the lawyers, because this webinar has been put together under the umbrella of the East African Law Society. And so we really want to know the bread and butter of the lawyers. But I'd like Judge, even as a response to that, respond to two interesting questions. Number one, in Kenya, other than mediation, please clarify other ages mechanisms that we have. And please, we can be brief because I know there are quite a number. And number two, on the issue of data, how important is data? Because this has come from Michael. The first question has come from Melissa, and thank you so much. How important is data on the costs associated with diverse pathways to justice versus the formal justice system in terms from the policy perspective? Why do we need to invest in data? So you can combine those three questions. Thank you. Judge?
Thank you. And let me begin just by appreciating my fellow panelists. It's a really great panel. I am very privileged to be with all of you. My friend Andrews Kamanga, we've been on the trenches on AJS, I think since 2013, maybe 2012. So it's been a long time. It's good to see you and to see that we are still going strong. Barbara, I think we've been on this since 2016, and I'm very glad to make Zenobia's acquaintance. I'm a little offended that I've never been invited to Cape Town. I believe that has changed. Starting in March of next year. I am looking forward to that invitation. So very quick things. First of all, let me just bring it home. I know most of us are lawyers here. So there is a question that, oh, Patricia, thank you so much, by the way, Patricia. I know you've been behind the scenes in organizing this. We appreciate it very much, and I appreciate your quiet wisdom. So first of all, I think the elephant in the room is, what does this all mean for the practicing lawyer in this space? So let me begin there, because that's I think a question that most people have. Let me say, the lawyer of the future, the family lawyer of the future, must be one who must be capable of designing durable human conditions. Let's just get that clearly. That means there must be a lawyer. They must be a lawyer who can litigate. Litigate is not off the table. You must be able to litigate as a family lawyer. But also, it must be a lawyer who can negotiate. It must be a lawyer who is a problem solver. It must be a lawyer who is a counselor. It must be a lawyer who is a constitutional steward. But it also must be a lawyer who is a designer of sustainable outcomes. All those are now required under our transformative constitutions. You can't just be a lawyer who is holding on to civil procedure and whatever act and going to court and banging the table. That means you must be a problem solver. You must be one who is an expert in dispute resolution in whatever it guides. So having established that, let me just say a few quick things, first of all, about AJS, then return to it. First of all, the real question I think we are facing in East Africa and in most of Africa today is not whether we can shape these systems in ways that are constitutionally faithful. They are. The Constitution already constitutionalizes AJS. The question is, how as lawyers do we fit in so that we offer value added? Here's Here's what I think lawyers we need to understand. First of all, in terms of the fears about what this means for human rights violations, number one, and this is important for lawyers to hear, the Constitution does not constitutionalize culture. The Constitution constitutionalizes culture that is constitutionally compliant. That's number one. That already implies that there is a role for lawyers. The lawyers have to determine which culture is constitutionally compliant. Lawyers, it's a question of interpretation, it's a question of application. Secondly, then the lawyer then understands that when a client approaches them with a family law problem, the lawyer is not asking for litigation. The lawyer is asking, the client is asking for a solution, for her problem to be solved. So you must ask yourself, what is the mechanism that is best for resolving that? And as lawyers, we must abandon the view that we must start pigeonholing. Earlier today, I was in a presentation and I said, when we go to lawyers, the way we've been taught in law school, especially for those of us who are older, a client comes to you and you're already thinking, is that a tort? Is that a breach of contract? Is that a statutory interpretation problem? Is that a constitutional problem? You're already thinking about where to pigeonhole it in terms of litigation. I think we must just have a different skill set. The skill set we must have is to say, what is the problem here? What is the justice problem? And as a lawyer, how can I contribute? How can I value add to its solution? That solution might be in litigation. Absolutely. There are questions that you must go to court. Sometimes you just go to court to get a toehold, but not necessarily because you want the outcome. You get a toehold and then you pursue other means. Sometimes you are aware from the get-go, the solution is elsewhere. And in this regard, I just want to give you, for those of you who are really interested in this question, like Senior Musau and so forth, and other scholars, please look at the work that KELIN has done. KELIN is an organization in Kenya that has been working on the rights of women and widows, especially property rights in Western Kenya, in Kisumu, Siaya, and so forth. They have done absolutely fascinating work, working in the interstices between court and AJS. And that's an area, I don't know if we have anyone from KELIN here, but that's that is to me an indication that it's possible. They have been able to use alternative justice systems in very creative ways. They've been able to use courts in very interesting ways, in a way that I think demonstrates to lawyers the way of the future. Lastly, Jemima, let me just answer the question of data. Data is important, and we don't have enough data. We don't have enough data about plural legal systems. We had a webinar on this maybe 2 weeks ago. And I'm glad that it's Michael asking this question, because I think it's confirmation that it's coming for our conference. And what we don't have now is data that suggests all the benefits of alternative justice systems. We have plenty of data that suggests what the metrics of measuring court systems and tribunals, in terms of backload reductions, in terms of case clearance rates, in terms of all that. But we don't have enough, admittedly, in terms of alternative justice systems. And we need it. And we need to invest more on that. So the answer to that question, Michael, is that yes, we need to invest in it. We need to invest in finding more data that can lead us to make this case most powerfully and volubly. But I think from our own experiences, we already know and can see what the benefits of alternative justice systems are. What now we need to do is to follow it up with data. Let me end up there, and then maybe we can have a second round. I can answer any other questions. Thank you.
Thank you so much. And I think one thing that you didn't emphasize is the fact that our theme for the AJS Conference 2026, the biggest conference in East Africa and Africa at large, is data-driven pathways to justice. We're not looking at data
I think
just
you
as
mean the
numbers.
biggest conference globally on that question.
Okay. Globally, yeah, with international scholars and guests, and you'll be hosting Chief Justice from Africa.
I haven't
I've
had
said
the
them.
invitation.
You receive
But
after this. That's what we agreed. Yeah, I'm sending you. That's the discussion we had with you in the morning. So we have our conference coming up. It's a data-driven pathways to justice. This conference will be at the University of Embu. And I'll be sharing the email that you can be able to, if you want to receive an invitation, you can send. But for our panelists here, they have direct invitations after this panel. We're not looking at data just in terms of numbers. We're looking at data in terms of the experiences of people, the justice journeys, how they experience their journey to be able to get justice. One of them is you have disputes related to burial where parties are not in any discussion or in any conversation for years, waiting for this burial dispute to be resolved. At the end of it all, your deceased person is lying in the mortuary for years, yet you as parties are not having any, you cannot even share a cup of tea. We have an experience in Nakuru where this matter was handled through one sitting, and for the first time in 10 years, this family was able to share a cup of tea together. And so come to AJS, we not only serve you with justice, but also enable you as parties share a cup of tea. Our next respondent will be Barbara, and will be responding to two questions very, very fast. Number one is the role of lawyer, and number two is the issue of the vulnerable groups. How have you been protecting the vulnerable groups? Welcome, Barbara.
Thank you, Jemima. I think Judge hit it on the nail that the lawyer is the solution provider. So if we are solution providers, then that means we have to see ourselves beyond the wigs and the hoods that we wear. So that means that we can also be AJS practitioners. And I'm not talking about the cultural guy with the headgear and the traditional paraphernalia. I'm talking about informal justice mechanisms where they require where there's peer appointment. So in your local communities, in your administrative circles, you can be an AJS practitioner. So that it is beyond that. So not just thinking about it from the legal representation bit, but also in the justice provision avenue, where now anyone who's selected by the community can provide justice services. On the question of inclusivity, and I'm grateful for that question, because entrenching inclusivity in any justice system, not just AJS systems, it involves embedding principles, rules, and practices that ensure equitable access, participation, representation, and practical outcomes for all the groups, including the marginalized, so women, youth, persons with disability, minorities, and others. So what is important is that whereas the law provides boundaries, which is where you have the rights that are defined, the equality principles that are defined in there, and dignity included in the law, it is the community that can ensure that this enforcement is actually inclusive. And that can only be done when we bring about their capacity to trust these institutions and to have confidence in them. The way we can do that is by making sure that they are aware. So empowerment is very important. People need to know that these justice systems exist, what they can do, and how they're supposed to do it. It is only then that they will be able to hold these institutions accountable, and inclusivity becomes practical. Because once people do not know that this is how a system is supposed to operate, they are unable to hold it accountable. So my answer is, when we improve the access, because inclusivity will not just be about access, but if we ensure that those who participate, those who have power, and those who decide the disputes and can confirm that the outcomes are fair for all, by strengthening and embedding safeguards through public awareness campaigns, ensuring that there is representation, then the accountability mechanisms that would be enforced by the communities themselves will ensure that there is participation, and not just participation for the sake of it, but meaningful participation for all those who are involved, and that these structures actually appreciate and enforce the principles of natural justice and human rights, then we can confirm that then these systems would be inclusive and we can actually hold them to that word and find them to be appropriate and accessible to all the partners. Over to you,
Thank
Jemima.
you so much. Thank you so much, Barbara. I actually, you've emphasized our provisions in the Constitution. That is Article 10 and Article 27. And they need to ensure inclusion, participation, equality for all, including the marginalized communities. I'll go to Andrews. As you respond to the question on the role of advocates and whether we are actually denying them their bread and butter. The also question that you need to respond to is how do we ensure accountability from the agency practitioner? You've given us different mechanisms that exist in Rwanda through paralegals, mediators, family, friends, community conferencing. So how do we ensure accountability? So you can be able to respond to those two. Thank you.
Sorry, Jemima, you are breaking. Can you repeat the question? You were breaking.
Okay, sorry. You are responding to the first question on the role of lawyers. Then couple it with the question of how do we ensure accountability of these mechanisms. And you've highlighted different mechanisms in Rwanda that are working, the use of the local community structures, family, friends, community conferencing. So how do we ensure accountability? Thank you.
Thank you very much. Very quickly, I think it has been said clearly by Prof. and Barbara. I think lawyers don't have to worry about their future. But what we have done here in Rwanda actually now, most of is just to tell lawyers that ADR is the way to go. And lawyers who are actually, at the moment as we speak, those who are earning a lot, those lawyers who have embraced ADR. Because ADR, broadly speaking, not only family law, but those who are doing ADR practitioners, they're earning a lot of money because it's the way to go. It's not litigation, and I'm glad former Chief Justices, one of them, I think, Professor Joel knows him. They're setting up their own because this ADR thing started when they were in office. Most of them, to be exemplary, they're setting up their own law firms to focus mainly on ADR. So what we are trying to do in Rwanda, we are trying now to regulate a little bit, especially from those we are enforcing capacity building training for private mediators. And if you look at our mediators who are involved in ADR, most of them are like 70-80%. Of course, we're also encouraging other sectors of the economy to be involved in ADR so that we reduce the number of cases that go to court. But I think ADR is the way to go globally, not only in East Africa, and lawyers are around to be part of this system, and they can charge as they wish. And I believe I have one case we've just settled that involved real estate and divorce at the same time. There was a lot of money involved. I was told that our lawyer was paid about 20 million Rwandan francs. They never went to court. They were able to resolve it. And there are many, many cases of this nature. So I think what we need to encourage our lawyers to do is to embrace the ADR, get trainings, and try to, distract their business, factoring into ADR, in construction, in every sector, in mining. This is now the trend. Any lawyer who would want to rely on litigation, I think, my sister, my brother, senior counsel, is not. You should just understand all the countries in the region are embracing ADR. I was in Uganda a couple of weeks ago. They're talking about the same. Before that, I was in Ethiopia. The topic is the same. ADR, I think, is the practice now. On issues of accountability, it's true. I want to link this issue of accountability also to data, because when you don't have systematic way of recording data, the structures of ADR I talked about earlier in Rwanda, we are facing a challenge of not having real-time data on what they're doing. Their structures set, recognized in our law, but when it comes to data collection, it becomes a problem. Because, and this is very important, maybe something we'll be discussing at your conference, it is believed that 80% of the conflict we have in Africa, in developing countries, 80%, 80, they are being managed within these systems. So it would be unfair if countries, our region, can't focus more on how ADR can be made very systematic. If 80% of the disputes, we only get to see 20% going to our courts. So can you imagine? So now this is, if you want to also look at it in terms of market for lawyers, many cases are being dealt with within ADR systems. Thank you.
Thank you so much, Andrews, Kananga, and also a call to the lawyers to be able to diversify, just as we were discussing about diverse pathways to justice, we also need to diversify. You know what Justice Ngugi asked us to do as lawyers? To be, to look as lawyers as to provide durable solutions, and it asks us to be not only litigants, negotiators, counselors, but also setting standards. And so this calls on us to be able to embrace alternatives, pathways to justice, or diverse pathways to justice. I'd like to bring on board Zinobi. And even as Zinobi responds to the question on the role of lawyers in South Africa briefly, she'll also be able to look at the question on forcing parties. Do we force parties into AJS mechanisms or not? After Zinobi, there's one important question I don't think Prof responded to, is what are the mechanisms existing in Kenya? We have had a whole array of mechanisms in Rwanda, but now let's bring it back home. What do we have in Kenya as alternative justice mechanisms? So those two questions briefly, and we are just about to wind up in 15 minutes. So if you have any question or comment or compliments, please put in the chat. Zinobi?
Yes. Firstly, let me say, as far as compulsory mediation is concerned, it's now, in terms of our High Court Act, for example, compulsory to mediate at certain stages of the formal proceedings in court. Otherwise, you don't get a trial date in a court eventually. But also, there may be adverse costs orders that may follow. You can opt out of mediation, for example, at any stage that you want. There's a period within which the mediation takes place, and if there is no outcome, the mediator files a no outcome certificate and the proceedings carry on. So there are certain opt-out provisions, and of course, pure legal questions is difficult to mediate as such, unless they are lawyer-assisted in mediation as such. As far as lawyers are concerned, there was a huge groundswell of opposition in South Africa originally when ADR started becoming popular. So big fear of loss of income, loss of clients, taken over by the ADR system. And exactly the opposite has happened. I'm more busy than I ever was. Mediation is a very good process to find satisfactory solutions for parties who are extremely happy at the end of the process. And we've always got to remember that we, as officers of the court, have an obligation to retain the fabric of family and to act in the best interests of children. And to do that is not to align people in a very bitterly acrimonious process. In mediation, one advises the clients from time to time. I have many clients who are in extended mediation processes who come back regularly for advice. You prepare them, you give them the parameters of their rights, and you strategically and from a legal perspective advise them throughout the process. If that doesn't happen, you don't have equality of playing fields and you don't have good outcomes. The process is speeded up. You can decide how the process is managed, and you very much also assisting in that process. Arbitration, of course, you're fully involved. Both these processes are much, much cheaper in South Africa than opposed litigation. You may litigate till the last breath, but you will find that the outcome you reach is so reduced by the costs that have to be paid by both parties. Firstly, that it is actually a less welcome outcome to both parties. And you know, the old saying of a good settlement or a good outcome makes both parties unhappy doesn't work in families as such. You do want to retain the fabric of that family. You want to retain communication, their 21st birthdays, marriages, grandchildren, etc. coming. So the delays in litigation as well has really torn families apart. It's become very, very difficult for family law to be effective in these circumstances. So mediation can be quick, very cost effective. Lawyers are fully involved. There can be lawyer-assisted mediations, which very often happen because clients feel that they're intimidated by someone who's perhaps more commercially savvy than they are. So they want you to hold their hand in the mediation. You sit separately, and it's very much the concept of a roundtable meeting, although you are lawyer assisted in a mediation session. Let me leave it at that. You can also have very singular matters go to mediation. For example, where personal maintenance for a spouse is in dispute, send it to mediation. It might otherwise hold up settlement of the whole process.
Thank you so much. Sometimes you're told that lawyers are not business people. And why are they not good business people? If you have 10 files and you're getting the round turnaround time, you get more than having one file for 5 years. So think about that, even as you think about the role of lawyers in promoting the diverse pathways to justice. So before I bring Prof, because I want him to be the last one, I want to go to my panelists with 1 minute each to just say the parting shot. What will you remember you for as a parting shot in people-centered justice? What will you as parting shot? Barbara, then Andrews, and then Zenobia. Then I bring Prof to be able to respond to the last questions.
Thank you. Thank you so much, Jemima. So my parting shot would be, the future of justice lies in recognizing and strengthening the diverse pathways that people are already using. So the plural systems that can advance access to justice when they are treated as connected ecosystems, supported by evidence, back to our data question, anchored in rights, and designed around people's needs. And I think then we would have learned our lesson, and justice pathways will be implemented in a manner that promotes access to justice and enforces equality before the law for all. Thank you, Jemima.
Thank you so much. So Barbara, that punchline, I will be able to use your photo, have a punchline, and use it for our AJS conference 2026. Andrews.
Thank you
What
very
is your
much.
punchline?
So Rwanda also has, and East African countries, I think it's time we continue strengthening ADR. Not only, I mean, today's focus has been family law, but I think broadly speaking, ADR needs to be strengthened. We need to focus on reforms. A lot of countries in East Africa, I know Uganda, Kenya, Rwanda have adopted new policies, new laws regarding alternative justice systems, or ADR, whatever you want to call it. We should now, I mean, the next phase is now to institutionalize and try to do the necessary reforms to promote accessible, efficient, and community-based justice system, so that we do not have to rely on litigation. And I call on our participants and the followers to, to embrace alternative justice systems, because this is the only way to go. Our courts being bothered by a lot of case backlogs that have been with them for so long. The Honorable Professor gave examples of a case that was in court for 9 years. So, I mean, justice has to be seen to be done, and that involves, making sure that we deliver justice in a reasonable time. And ADR is Africa. It is our tradition. It's high time we revisit all these concepts and make sure that justice is within the reach for people. Thank you very much, and thank you for inviting me.
Thank you so much, Andrews. Thank you. Yes, yes, AJS is Africa, going back to our roots, going back to our culture. But the most important thing, we need to promote people-centered justice and be able to restructure so that people can get justice. Actually, we're just promoting diverse pathways. Zinobi.
I think ADR is definitely the future, and it's becoming more and more so internationally. I would like to see that diversity is celebrated in mediation or ADR processes and taken into account, and even perhaps members of a specific culture or religion co-opted into the process. I also think that lawyers must loosen themselves from the procedural challenges of litigation, think laterally and innovatively as to the methods or the structures within which they can mediate and arbitrate as such. There could be wonderful quick solutions for single problems or multiple problems, and we should not be afraid of trying to use this innovation together with ADR with multiple structures. Thank you.
Wow. Thank you so much. The call for innovation for the lawyers, the call for us to be able to embrace a mediation, ADR, and alternative systems, because that is the future. We are actually in the future. There's no other future. We're already in the future. So don't wait for another future. Justice Professor Joel Ngugi, there are two questions that I'll like you to respond to. The first one, what is the harm in the judiciary regulating? I think the question about regulation of ADR spaces, that's the question. Then number two, on the constitutional aspect, does the constitution provide a scenario whereby parties will not be able to use alternative justice mechanisms? The second, then the third one was the issues, what are the existing mechanisms in Kenya? So give it very, very, keep it, like kiss it up, keep it short but sweet, and then give us your parting shot so that we'll use that for the AGS Conference 2026.
Jemima, because I don't trust myself to answer briefly, especially the third question, can I ask you to answer that question about the mechanisms and then I answer the other two?
Yes.
Thank you. Please go ahead.
So we have three mechanisms in Kenya. Number one is the autonomous mechanisms. How AGS is fashioned in our communities. How do we resolve cases within our communities using our community leaders, using our clan leaders, our family leaders, our chama leaders, our business leaders. In the estates where we live, we have several disputes that arise, but we have our leadership structures that we use to be able to resolve disputes, and they are fashioned in different ways. Those we call autonomous. The second one is a third party. Under the third party, we have the state-based mechanisms or institutions that resolve disputes. For instance, use of the police, the chiefs or the Ngao, the DPP with his policies on diversion, plea bargaining, alternatives to prosecution. That's also one mechanism that's called third party. Probation officers. And because you're talking about children matters, the children officers give summons to parties and they're able to have amicable solutions at that particular level. The use of mediators that we call paralegals here. Then we have this the civil society, the third party non-state-based, where we have the civil society organization institutions like FIDA, KELIN, that Prof mentioned, Kituo cha Sheria, Kenya Human Rights Commission, Pamoja Trust, and others. Faith-based organization using our religious leaders, including the imams, the sheikhs, through different mechanisms. That we call the paralegal, so that we call the third party non-state institutions. Then we've also come up with another mechanism called the court annex mechanism, where we form a pool of practitioners from diverse backgrounds, including the elders. So it's a pool. So you can be an elder, you can be a children officer, a probation officer, you can be a religious leader. We form that to be working directly with the court, just the same way we have the court annex mediation. So we have the court annex AGS mechanism, where the court makes the direct referrals. And one example that judge gave, which is working very well, and if you want to benchmark, is Nakuru. So Nakuru has an AGS court annex AGS mechanism where the court refers these matters to AGS. So one of them was this family dispute that had stayed for 9 years, but within one sitting, the panelists were able to resolve and report back to court. And the second one is the one that I mentioned, where it was a burial dispute and parties were not even in talking terms for years, and the body was lying in the mortuary. But through one sitting, they're able to come up with the amicable solution, and now even shared a cup of tea in court. Thank you, Judge. But I'll be able to share with you these mechanisms through the different platforms, and you'll be able to read. For the scholars, reach out. As you've heard, the next Daktari is here. Back to you, Judge.
Thank you, Jemima, and thank you again to my fellow panelists. I will answer the question very quickly. So the question is, what would be the harm if the judiciary took the bull by the horns and regulated AJS? In Kenya, at least, and I believe it's across Africa, the judiciary is not constitutionally permitted to regulate AJS, and for good reason. The constitutional commandment is to promote AJS. That's in Article 159(2)(c) of the Constitution. To promote does not interpretively mean the same thing as regulating. To promote, at least in Kenya, we have defined it to mean three things: to protect AJS, so to do no harm to AJS, to make sure that parties do no harm to AJS, and thirdly, to transform AJS, to ensure that they are in keeping with human rights minimums. That does not equate to regulating. Regulating is basically what colonialists tried to do with African customary law. And in our transformative constitutional setup, that is no longer permitted, because it's a way of saying we don't trust people to do their own things. In Kenya, at least, and across Africa, what our constitutions have done is to give people civic autonomy, to aggrandize that civic autonomy, and to increase their agency in making decisions. But at the same time, to give the judiciary a role of being a transformative agent, to ensure that if there are cultures that are being applied, if there are dispute mechanisms that are being applied, they're in keeping with the constitutional minimum. So that is a short answer to it. But this is a whole seminar, which I know Patricia Mundia can organize for a future date. Jemima, what was the second question to answer?
The future date, we shall have it in Cape Town. We shall be carrying our suitcases to Cape Town and having this conversation.
I like that. What was the second question, Jemima?
The second one was the constitution. If does it qualify parties from embracing AJS? So
Absolutely.
In brief.
So yes, in brief again, the constitution, at least the Constitution of Kenya, does exclude and gives us indications of what is excluded from AJS. Now, in Kenya, we have what is called the AJS, the agency theory of jurisdiction, and that is derived from the Constitution. The two things that I can tell you for a fact that the Constitution excludes from AJS is, one, our Constitution of Kenya, because of our specific electoral injustices history, excludes presidential elections from being amenable to AJS. Okay, that's constitutional. But secondly, the Constitution implies quite explicitly that any matters that involve directly the violations of the rights of children cannot be subjected to AJS if they are of a criminal nature, which means the court can undertake a protective jurisdictional stance, standing in the place of the minor if it must go to AJS, but the minor cannot participate directly without the protective jurisdiction of the court in AJS. That's a little complicated, but that's also for future doctrinal analysis. But also in Kenya, we say under the agency theory, there are statutes which exclude AJS. And the Constitution of Kenya says if a statute excludes AJS, then that matter cannot be amenable to AJS. So for example, the Sexual Offences Act in Kenya excludes sexual offenses from AJS. So just to answer very briefly that. In terms of the parting shot, I want to say this. The real question for lawyers is not whether AJS will shape family law in Africa in the future. It already is. AJS is already shaping family law in Africa today. The real question is whether we can shape these systems and whether we can equip lawyers who will steward these systems so that they are constitutionally faithful, socially legitimate, and ultimately people-centered. And in my view, like I had said earlier, the only way we can do that is to shape that future lawyer to become a designer of durable human conditions. Thank you. It's been a lot of fun.
Wow, designer of durable human conditions. Thank you so much, Judge, for your punchline, and definitely we'll use this as we promote and be able to talk about AJS and people-centered justice. Ladies and gentlemen, in Kiswahili we say kilicho na mwanzo lazima kiwe na mwisho, na tumeweza kufika tamati. Mimi ndio nilikuwa mwendeshaji wa this webinar. My name is Jemima Aluda. I'm the head of Secretariat for Alternative Justice Systems, but I've been told to call myself doctor. So I'm proclaiming that title in Jesus' name. And I want to hand over to Gabriel. Thank you so much, the panelists. It's been quite interesting discussions, and the call for us to promote diverse pathways to justice, people-centered justice, and alternative justice mechanisms. Depending on which term you want to use it, all in all, look at the rights of the child, the rights of the widow, the rights of the vulnerable group, the rights of that family that you're talking about, because that's the fabric, unit that we have in the society. The most important thing is justice for all. Back to you, Gabriel.
Wow. Thank you, Jemima, for such an incredible close to the session. It's really been one that has been quite insightful, and we've really taken down quite a couple of notes from our end. And I can tell you for certain, feedback that has been flocking me, for example, has really been good. I will share some of that feedback with you after the session. But I would like to, on behalf of the Secretariat of East Africa Law Society, our CEO, Mr. David Sigano, President Ramadan Abubakar, would like to thank you for this very wonderful session, for this beautiful partnership that we have entered in with AJS and IFL. These sessions keep equipping us more and more and more, and we couldn't be more grateful to you, Honorable Justice, Professor Joel M. Ngugi, Madam Barbara Kiley, to you, Mr. Andrews Kananga, our able chair, Ms. Patricia Mundia, and to you, Zenobia Dutoit, this very wonderful session that you have given us. You've left us wanting more. As it's written in one of my favorite books by Charles Dickens, Oliver Twist, where he says, "Please, sir, can I have some more?" So AJS, IFL, can we have some more of this session next month? And let's continue engaging as we equip our members more. From the Secretariat, we look forward to sharing a recording of this session with all our members, so that you can re-listen and take down some of those beautiful points that have been shared on the call. Also, you can visit our website at www.elawsociety.org, or visit our YouTube channel at East Africa Law Society Official for you to get rewatch this recording. With that said, I would like to thank you so much for attending this session. I do not know if Patricia, you have any words to give in closing remarks, or we bring it to a close.
So even as she brings this to a close, we have 2 or 3 other webinars we are organizing. This was part of our pre-conference webinar. We have one on gender justice on 28th, that is next week. Please follow us on Twitter, on Facebook, on our upcoming webinars. We have a webinar on the role of paralegals in promoting AJS, and we're also organizing another webinar, which we'll be able to share in June. But we also have another webinar on ADR and how we can link between mediation, arbitration, and alternative justice systems to be able to demystify the monism aspect that you have on 11th of June. Follow us on our Twitter handles and our Facebook, and please join us in this thought-provoking pre-conference webinars. Thank you.
Thank you. Over to you, Madam Chair.
I don't have much to add, only to say that I appreciate everybody who's been involved in coming up with this session, and all the participants who've also participated through the chats, through the feedback that you've given us, and also the panelists. I can't forget, it's been eye-opening, and I hope we can have more of these sessions in future. So thank you all.
All right. Thank you all. Have yourselves a lovely afternoon until we meet again next week for a set of other webinar sessions on alternative dispute resolution. And we'll also have a series of them packed through the month of June. Thank you, and have yourselves a very lovely afternoon and blessed weekend ahead. Goodbye.
Bye-bye. Thank you.